and thank you for joining us. My name is Katie Perez, and I'm a senior associate here at Scott Legal PC, based in New York City. Today, we're going to spend some time talking about the National Interest Waiver rules and requirements, but just a few things before we get started. Some of you may know that the firm was founded on an E2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E2 visa and has been on several different visas, including an F1, a TN, the B, and an H1B. So Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including E1, E2, TN, L1, family immigration, national interest waivers, EB-5s, extraordinary ability visas, and more. So we will continue this webinar series, doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today, a link where you can also download the guides that go through the visa options in more detail. We'll also send you a link where you can sign up for additional webinars. This webinar will be recorded and it will be available on YouTube. We'll also send you a link for that. We do encourage you to subscribe and hit the notification button, as we do regularly upload immigration videos on a wide variety of topics. And we'll also send you a link where you can arrange for a consultation with one of our experienced attorneys if you would like to discuss your case in more detail. If you have any questions throughout this presentation, please put them in the chat box and we will address them at the end of the presentation. So today we are lucky to have another senior associate here with us, GA Wong. She will be presenting the first half of the webinar. GA is a senior associate, as I said, here at Scott Legal. She does have an exceptional academic background, holding a JD from NYU, a master's from Columbia, and a BA from Harvard. So GA also has extensive experience processing employment-based visas, including the NIWs. So without further ado, we will get started. So let's see. All right.
All right. Thank you, Katie, for the introduction, and thanks everyone for joining us this morning. So let's start with an overview of what is an NIW. What do we mean when we speak of national interest waivers? So a green card petition through the EB2 NIW category is a green card option that can be available to applicants when the government concludes that you're coming to do something that is in the national interest of the United States. Now, there is a very specific way the government interprets what is the national interest, and the adjudication trends for that does tend to change over time. So it is very important to always keep current with how currently the government is adjudicating these cases, because really the NIW is a discretionary benefit, and the waiver, when we speak of a waiver, it relates to the requirement to get a U.S. job offer and get sponsorship from a U.S. company, which is the ordinary requirement. But if you can show that your case is, has that special factor that the government is looking for, then you're able to self-petition for a green card under this category. And that is why the EB2 NIW is such an attractive option for many individuals who, for some reason, either don't want to or can't get a U.S. job offer. However, in order to get approved for a national interest waiver, the bar is quite high. You need to really show the government why what you're doing is so different from, the ordinary case where a U.S. employer, needs your work and needs the benefit of your particular services, but your work is qualitatively different from that and has a much broader impact to the field, to society, or a technological advancement or things like that. You do need to show that special factor that the government is looking for in order to be exempt from the ordinary requirements to get a labor certification, to get a U.S. company to sponsor you. So it's really not the easiest pathway to a green card, and can be quite discretionary when the government approves this waiver. So that's one way to look at that. So as I mentioned, the NIW is a subset of the larger employment-based green card program. So specifically the EB2 category. The EB2 category is for people who have an advanced degree, which is defined as a master's degree or above. If you also have a bachelor's degree in your field and 5 years of progressive work experience, you can also be considered the equivalent of an advanced degree holder. Or if somebody has exceptional ability, that's the EB2 category as a whole. But within the EB2, larger EB2 category, is just a subset of cases that have that special factor to be exempt from the labor certification requirement, right? So ordinarily, even if you have a master's degree, even if you have exceptional ability, you still need a job offer. You still need a US sponsor. But if you have that special factor, then you can self-petition. So that's what the NIW is talking about. So naturally, because you're trying to qualify for this special waiver, NIW cases have a much higher bar than perm-based company sponsorship, which is the ordinary way U.S. Congress wants you to apply for a green card, to get a U.S. job offer, to have that, employer sponsor you. But because you need to show that you can be exempt from that, there needs to be a lot more that you need to prove. So how do you qualify for an NIW? How do you get exempt from this requirement? NIW adjudication has a three-part requirement test based on a recent case from December 2016. It's called Matter of Dhanasar. And in addition to meeting those three-prong Matter of Dhanasar criteria, you must also meet the EB2 threshold requirement. And I briefly mentioned this, but you need to either show that you have a master's degree, a bachelor's, or 5 years of work experience, or have exceptional ability in your field. We'll talk a little bit more about that on the following slides. Now, and as I mentioned before, in the above bullet points, you do not need an employer to apply for a green card under the EB2 NIW program. And that is one of the reasons why it's such an attractive pathway for many people. Now, the waiver relates to the ordinary requirement to prove that a U.S. employer needs to give you a permanent job offer. And then not only that, but usually the employer needs to test the U.S. labor market to see if there is any other qualified U.S. worker to fill that particular position. And that is called the perm labor certification requirement. But if you can show that your case merits an NIW, this means you don't need to find that job offer. You don't need to have that US company sponsoring you and going through that perm process, which can be a pretty lengthy process and a complicated, process. But let's say you're working on a project that can have a huge, broad impact to a very important technology for the United States. And if you can show, maybe US government agencies are interested in the outcome of this particular research, and if that can really, change best practices for the field as a whole, maybe the government can feel that, okay, your particular work will have much broader benefits than what a U.S. worker with minimum credentials can offer. So we will, exempt you from this requirement. So that's sort of how the NIW works. You need to meet the challenge of proving to the government why your case merits this special treatment. And therein where is the challenge. One other thing to go over before going to the next slide is that applicants in any field can apply for the NIW. And it is not true that only STEM fields can apply. So even if you're not an engineer, even if you're, maybe you're in philosophy and you're, developing a new framework for understanding a particular area of philosophy, and let's say, you are sharing your research with, many different experts in philosophy, and you're impacting how other philosophers are looking at this particular case. So if you can show influence in your field, you can certainly apply for an NIW based on that broad impact to your field. It doesn't matter what your field is, right? So we've had approvals for, entrepreneurs who's working at the cutting edge of design. We've had approvals for, entrepreneurs who are, researching agricultural technology. So really, it's not the field that's important, but it is what is your specific proposed endeavor and what is the prospective impact of your work on the field. So even if you're working in a very attractive field like AI or cybersecurity, not every engineer who is a cybersecurity engineer is going to be approved for an NIW. And that is definitely a misconception, that if you're working on AI engineering, then you would automatically get approved for an NIW. Actually, the answer is no. If you're just doing AI engineering that any other AI engineer can do, then the government is going to say, well, okay, well, that's great that you're an AI engineer, but the normal way Congress wants green cards to happen is your employer would test the labor market to see if there is any other US minimally qualified AI engineer who can take your job. So if all that you're doing is to help one single employer, with your AI engineering services, then the USCIS is going to say, unfortunately, this is not a case for an NIW. This is a case for perm. So definitely, this is a very important distinction to make, right? It is not the field that you're in that's important, but it is what you're doing in that field. And we'll go into a little bit further detail on what that means. All right, so we'll move on to the next slide. All right, so now let's talk about the threshold requirements, which is the minimum requirement before you can even try for the NIW argument, which is governed by the three-prong Matter of Dhanasar test. But before that, you do need to still show that you meet the EB2 threshold. So how do you meet the EB2 threshold? Either you show that you have an advanced degree, which is defined as a master's degree or higher. Or another way you can show that you're an advanced degree professional is that if you have a bachelor's degree and if you have 5 or more years of progressive work experience in your field after you had received your bachelor's, then you can also qualify as an advanced degree professional. Now, important things to note is if it is not a US degree, you do need a US education equivalency report that confirms that this is the same level degree in the US standards. So certain master's degree from certain foreign countries, actually, when you do that evaluation, you get the report and they say, oh, actually, this is equivalent to a bachelor's. So that can be a surprise for you. So if you're thinking of potentially applying for EB2 NIW, definitely maybe you want to go ahead and get the evaluation first to see if this is actually a master's degree as the US per the US standard, or if it's a bachelor's degree, in which case you would want to think of whether or not you have the five or more years of progressive work experience to use that. So those strategic considerations can be very important to make sure that you do in advance. When we speak of progressive work experience, it is very important to prove that the work that you've been doing for the 5 years is not only just for the period that's required, full-time 5 years work experience, but also you want to make sure that you get detailed letters confirming from your previous employer that the work duties that you've been doing tended to increase in complexity over time. Because when we say progressive, it means progressive change, right? So you shouldn't have been doing the exact same things for the 5 years, but you do need to show that, you've been given more senior responsibilities as time went on. Maybe your title changed. Maybe your job title started from junior engineer to senior engineer, then to principal engineer. So maybe there was that, or maybe your salary rose, or maybe you were just given more leadership roles, or supervising more people in your position. So there can be many ways to show that your role was progressive, but there must be that detail in the letter that you get from your previous employer. So the government will be looking for proof of that with concrete detail. So let's say you don't have a master's degree. Let's say you don't have a bachelor's degree. If you can show that you have exceptional ability in your field, in the sciences, arts, or business, you may be able to still qualify under the EB2 threshold. So it's important to know that exceptional ability does not mean extraordinary ability. Those are two different things. Exceptional ability is defined as a degree of expertise that is significantly above what is ordinarily encountered. So you don't need to show that you're one of the small percentage that are risen to the very top of the field. That's for extraordinary ability. So it's a little bit easier to meet practically. You just need to show at least 3 out of the enumerated criteria here. I won't go into too much detail on those criteria, but one important thing to note is one of the criteria is that recognition for your achievements and significant contributions to your industry or field by your peers, government entities, professional business organization. That is kind of a broad catch-all category where you can use so many different types of evidence. So there can be some room for advocacy there. So let's say you've received industry awards recognizing your contributions to the industry from a professional association. Let's say you're a lawyer and you've, received the best lawyer in, I don't know, contract matters or something like that from the American Bar Association, things like that. That can be a type of, award. Or let's say you've published, papers on journals, and let's say those journals, many people have been citing your paper. So you can provide a Google Scholar with, citations. That's another way you can meet, you can show recognition for your achievements. Let's say you're a startup founder and you've been, accepted into Y Combinator or Techstars. That's also a form of recognition from the industry. So really, there can be room for advocacy when you're, thinking of what evidence could show recognition. So definitely think creatively when you're, trying to think whether you could qualify under exceptional ability as well. All right, so now let's move on to talk a little bit more detail about the three-prong Matter of Dhanasar test, which is really the main part of NIW eligibility, because a lot of people can meet the EB2 threshold, but not everyone could satisfy all 3 prongs of the Matter of Dhanasar test. So I dare say that the Matter of Dhanasar test can actually be the more challenging part of a successful NIW application. So let's dive right into it. So the first prong under the Matter of Dhanasar test is to prove that the applicant's proposed endeavor has substantial merit and national importance. And really, the important consideration is, what does that really mean, right? So let's go into that. Step 1 in the NIW process is to clearly define the endeavor. And it is very important to note that a proposed endeavor is more specific than simply proposing to work in an occupation. So let me give an example. If a pilot says, okay, my proposed endeavor is to come to the United States and work as a pilot. And because there's a shortage of pilots in the United States, my presence in the United States as a pilot is of national importance. Now, do you think that would be a winning NIW argument or not? And actually, the answer is no, right? And the reason why is because the government thinks that a proposed endeavor must be more specific than simply proposing to work in an occupation. So let's give another example. Let's say you are a pilot, but you're also an engineer, and you're developing a new training software for pilots, kind of a device that can make pilot training much more economical and efficient than actually using planes for flying. And I'm completely making that up, but if there is indeed that kind of proposal, and if you can show that this solution will have a broad impact on improving best practices in pilot training, then that's another type of endeavor. And that's closer to the type of endeavor that the government is looking for, because the government not only wants to hear what your occupation will be, but the government wants to see what you will be doing within that occupation. So what will you be doing as a pilot? What is the specific project that you'll be working on as a pilot? Or if you're an engineer, if you're a, an aerospace engineer, if you're developing a new type of engine that is faster than the cutting edge, right? Or something like that. Or if it's something that will, use less energy than previously existing options, that's something that will, advance the best practices in the field, as opposed to you saying, well, I'm an aerospace engineer and I would like to come to the United States to continue working as an aerospace engineer. So that type of occupation-centered proposed endeavor is unfortunately not going to work, but the government is really looking for a specific and concrete proposal on what you're doing as, somebody in your occupation. So that's a very important distinction to keep in mind when you're thinking of NIW eligibility. Now, one thing to note is that geographic scope is no longer the focus after Matter of Dhanasar. So your work does not need to physically touch every single state in the United States. And another way to think about it is endeavors that have global or national implications within a field, such that if you're improving best practices that can be cited by multiple people or that can be used by other researchers in your field, that kind of impact, regardless of where the researchers are located, that can be seen to have national importance. So the way to think about it is the physical location of your work does not matter. You can be working at one particular university in, the United States, but if the impact of your research goes beyond that, then that's what the government is looking for. And examples that the government gives are things like improved manufacturing processes or medical advances, such as developing a new and more effective treatment for a particular disease or improving diagnostic technologies for a particular disease. And really the importance here is, are you improving upon what's already in the field, right? Because just implementing what's already out there, anyone can do if they're in the field, but only a few can really provide innovations that will push the envelope of the field as a whole. And the latter part is what the government is really interested in. Now, another way to meet the national importance is to show that your work will have substantial positive economic effects, right? And this can be relevant to entrepreneurs, but one of the things I want to emphasize here is that the scale of the impact is very important. So if you have a very small business and you only have 3 to 4 employees, for example, that kind of economic impact is actually not what the government is looking for an NIW. The government is looking for an economic impact that is proportionately significant in response to the circumstances of that particular region. So if you're going to be hiring a large number of workers in the region, right? That kind of thing. If you're going to have hundreds of employees working on a very large redevelopment project, for example, like the Hudson Yards project or of that nature. Not every project will be like that, but you can think of it as kind of a larger scale initiative that the government is really looking for in terms of the NIW, because there are millions of businesses. But not all entrepreneurs will qualify for a green card, because not all projects will be seen to have national level importance. So it's really important to think of, those distinctions in scale and the broadness of the impact. Now, as I mentioned before, the benefit of your work must go beyond one's immediate employer or clients. So if you're an engineer and if you're only working on developing products that is important for the bottom line of a particular company, even if it's for Google, even if it's for Microsoft, if your work will just benefit that particular employer, unfortunately, that will not be a case for NIW. The government will simply turn the case back at you and say, well, if it's only going to benefit the employer should have been sponsoring you with a perm. So that is how the government is looking at NIW cases at this point. Substantial merit is the easier standard, but you must achieve both substantial merit and national importance, and national importance often focuses on the larger scale and broader impact of the endeavor. Job shortage issues in the United States does not mean that the profession rises to the level of national importance. And I did talk about this in the previous slide. Even though the US has a shortage of pilots, not all pilots will be approved for a national interest waiver. There must be something else where you're impacting the field in a broad way. Simply saying that you're going to be working as a pilot, unfortunately, won't get you approved for the NIW. Several appeal cases also point out some relevant measure of the nature of the activity for national importance. And For teachers, for example, the government takes the position that teaching activities only tend to benefit the direct students who receive the teaching, and that would count against national importance. So let's say you're a professor and part of your work is related to teaching, but part of your work is related to research. Now, if your proposed endeavor is just about teaching, then even if you're a professor, the government will say, well, the only people who are benefiting from your teaching are your direct students. That is not a national level impact. That is not the type of broad impact that we're looking for. But let's say your endeavor is related to research, and let's say you'll be publishing this research, and other researchers will be able to cite it. Or, if you're presenting at conferences, and other researchers will be impacted by, what you're doing and use that insight for their own research. Those kinds of broad impacts are closer to what the government is looking for when they are asking, is your proposed endeavor one that has a more broader national level impact? All right, so now let's go on to the next slide. Yeah. So the second part of the Matter of Dhanasar test is whether you can show that you're well positioned to advance the endeavor. And here the focus is not on the proposed endeavor, but of the individual. So your background, experience, education, can you show that you have a track record of success in your field? Have you published intellectual property, such as patents or journal articles, if you are a researcher? And if you have published, technology in a patent, has this patent been, implemented, licensed out to many different companies? That can also show influence in your field, which can be helpful for the second prong. Another question is, how far along is the endeavor? Can you show evidence of traction, interest from US institutions or contracts, especially if you are using a startup idea? Have you been accepted into incubators or accelerators? Those kinds of things, showing traction, can be helpful for the second prong. And similarly, if a business already exists, if you are in the United States on an E2 visa, for example, and you're already running your company, contracts and tax returns showing a pattern of growth economically, that can help with the second prong as well. The final and third prong is that you must be able to show that on balance, it will be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification in your particular case. And we can point to extraordinary ability considerations, such as, if you've received awards in your field, if you've judged the work of others, if you've published scholarly articles and things like that, those can be used as support that it will be hard to replace somebody who's at the cutting edge of the field like you with just another US worker of minimum credentials. So that's one way you can show that a labor certification will not be appropriate in your case because your skills cannot be replaced. You can also point to evidence from prong one regarding the broad impact that is expected from your work, so that the benefits of your work, such as you're developing a new cure for cancer, saving millions of lives, that would definitely be a much larger benefit than the ordinary benefit of saving one job spot for one U.S. worker. So you can talk about that. If you're an entrepreneur, you can use the fact that you will be self-employed and not be eligible for a green card under the traditional labor certification pathway because you would have ownership interest in your company and you can't really use your own company to sponsor you. So that can be one way you can show that on balance, it would be better to exempt you from this onerous requirement. So that can be another way for entrepreneurs to have that advantage in the third prong. So in conclusion, it is important to note that Dhanasar specifically notes that entrepreneurial work does lead to an NIW and states that it's fine if the planned venture doesn't succeed, as long as the applicant can show that there is a plausible basis for it to succeed. But keep in mind that you still need to show that you're well positioned to advance that idea, and that may require evidence of traction or, a record of success in previous and related endeavors. All right, so we'll move on to the next slide. Yeah, we'll go into a little bit more detail about national importance because that has become the linchpin of many denials and RFEs. Really, really important to precisely understand what the government means when they speak of national importance, because it's no longer just about working in an important field. It is about what you're planning to do within that field. So you do need to prove the importance of your specific proposed endeavor and not the importance of a field or occupation. And successful NIW cases will not fall into that fallacy. Expert letters can be very important on proving the expected impact of your work because generalized articles or generalized government pronunciations talking generally about the importance of a field is not going to be relevant evidence for USCIS. But if you get an expert from a government institution that covers the field that talks directly about your specific project and gives the argument of why this will advance the field, that's a directly responsive evidence to the question of what will be the impact of your particular project, right? So expert letters can be more specific way to provide that evidence of expected impact of your work. Benefits to one specific employer alone will usually not be enough. So if you're just developing software for Google, even if Google is a national level employer, and if you're just helping Google's bottom line, that will not be enough to support an NIW case. The government will simply say, well, then Google should have just sponsored you for a green card. So really a nuanced argument on your impact to the field is very important when you're trying to support an NIW case. Broader impacts to a field or region, a public at large. We can provide, the government provides a few examples here. A person developing a drug for a pharmaceutical company may establish national importance by demonstrating the prospective public health benefits of the drug, instead of solely projecting the profits that will accrue to the employer. Similarly, if you can show widespread interest in adopting or licensing a new technology that you're developing, a novel and important manufacturing process, or how the technology stands to impact the development of similar technology by other companies, that can be a good support for national importance. Finally, substantial economic benefit can be a basis for finding of national importance. If you do need to show, though, that you will be creating US jobs at a level that is significant with respect to a population or economy of a region. So you can see that the government is really looking for a larger scale. They're not looking for creation of 3 to 4 jobs and, just simply non-marginal revenues. Unfortunately, they're looking for a much larger scale that can be said significant with respect to a population. So those are some ideas that really provide more context on what the government means right now when they speak of national importance. Okay. We'll move on to the next slide. And I think now I think Katie is going to take us through the remaining topics.
Yep. Okay. Thank you, GA. Okay, so we'll just build off what GA has already shared a little bit and go over what would be included in your NIW submission. So as GA mentioned, the first step of that submission is showing that you meet that threshold requirement. So in other words, again, showing that you have that advanced degree, which was a master's or higher, the bachelor's degree, and the 5 years of progressive work experience in the profession, or meet at least 3 of the criteria for that exceptional ability. So if you are going to be qualifying off your advanced degree, you would submit just a copy of your diploma. If you're doing the qualifying with a bachelor's degree and the 5 years of progressive work experience, you still need to show that you have that bachelor's degree. So you would submit a copy of your diploma. Then again, the 5 years of the progressive work experience, and then you can show that with providing like detailed letters from your past employers. So again, I know GA mentioned a little bit of this, but you want to make sure not only that the letter confirms your employment with the past previous employers, but also shows it was a full-time job, and then really does describe your duties in detail and responsibility, and then show that they have been progressive over that 5-year period. So again, you want to show that you maybe perform some junior duties and then they progressed up into the senior level duties. Let's see. So then, again, I know GA mentioned this too as well, but just to emphasize, if you did earn your degree outside the U.S., you would need to show that you have obtained that academic equivalency report, just to show that the U.S. government can see what the foreign degree is equivalent to here. I think it's important to keep that in mind as well. Like that you might think the U.S. government will take that foreign degree, no problem, but just to avoid that request for evidence from USCIS, it is important to obtain that academic equivalency report before filing. So if you're going to meet the threshold requirement with the exceptional ability, I won't repeat them all here, but just as an example, say you're going to show that you have that 10 years of full-time experience in your occupation, then as an example of evidence that you could obtain would be letters from your previous employers documenting that 10 years of work experience. Again, the letters should describe your position, your title, how long you work for the company, your duties, what you perform, that sort of information. Similarly, another example would be if you have a license to practice in your profession, such as a medical license, you would want to obtain a copy of that license so that you could submit it as part of that supporting evidence. Regarding the exceptional ability criteria, I think it's important that if you can if you can show and provide evidence that you have as many as possible to submit to USCIS, that would help you because sometimes you might submit showing that you have met 3 criteria, but in response, USCIS says, no, actually, you only met 2, so here's a request for evidence. We're going to ask for more evidence from you. So if you do have more than 3 and they are solid, then I would say, submit as many as you need. That might help you avoid an RFE. So after you meet that threshold requirement, you will still need to show that you are eligible and you qualify for that national interest waiver. So again, like Jay had mentioned, the other part of that NIW submission would be the evidence that demonstrates that you meet the Matter of Dhanasar. So again, which would be first that your proposed endeavor has that substantial merit and national importance, that you yourself are well positioned to advance the endeavor, and then third, that on balance waiving that job offer labor certification benefits the U.S. So we'll talk a little bit just about the evidence you could possibly submit to show this part of the NIW petition and why they would matter. So there is no rule as to what you have to provide for this part of the petition. It would just be on a case-by-case basis, and you would, of course, want to try to obtain the best evidence for your case. So typically a strong NIW case does consist of maybe a comprehensive business plan or a really detailed statement which would address your proposed endeavor. The business plan might pertain more to entrepreneurs, those types of cases, but again, that detailed statement describing your proposed endeavor would really help the adjudicating officer kind of give them a roadmap of what they're looking at, what you're claiming, and that sort of thing. So you want to clearly articulate what you intend to do in the U.S., how your work goes beyond simply participating in your general field. And then I think USCIS and the officers will really rely heavily on this description because, again, it just does become part of that foundation for them to evaluate whether or not you meet that Matter of Dhanasar framework. Okay, so let's see. So to demonstrate that national importance, you might want to provide some contextual evidence. For example, this could include government reports, news articles, academic papers showing that the area you plan to impact is recognized as deficient or needing advancement. These sources can show why your work matters. It is important to be selective about this type of evidence and strategic because you do need to tie the evidence directly and specifically to the project you plan to work on. So broad evidence about the importance of the field as a whole usually is insufficient just to show you specifically will impact it. As an example, I think GA gave a few too, but just showing the U.S. has a shortage of engineers by itself would not be sufficient to show or establish that the national importance of your proposed endeavor if you're just going to be serving as an engineer performing those basic duties. Again, so even if you were to submit articles confirming that there's an industry-wide shortage, this doesn't demonstrate that your specific project has like that broad national impact. So again, just simply performing the basic duties for that occupation would not be sufficient. USCIS is really going to look for that direct relevance between the evidence and your specific endeavor, not just the field in general. Another type of evidence that can be really important would be those expert letters. So well-crafted expert letters can speak directly to your specific proposed endeavor, explaining not only what you intend to do, but why your particular project has that potential to advance the field in a meaningful way, or provide those broad benefits. So expert letters, they should be tailored to your work, and they can be a powerful way to substantiate that you have that substantial merit and national importance of your endeavor. Regarding those expert letters, you would want to obtain letters from recognized authorities in the field, people with strong reputations and credibility, maybe senior professionals or industry leaders. You would also want to obtain letters from people that know you as well. So independent letters, and then letters from people that know you. So the overall goal with the evidence would be to build a petition that it really gives a holistic view of who you are and what you're planning to do. Other types of evidence, you could include, um, let's see, to show that you're well positioned. Prong would be, you would want to consider for this part, just, do you have the skills, the background, the momentum needed to carry you and be successful for that proposed work? This can include um, a variety of materials. So, a strong starting point for showing that you are well positioned in the field can be your resume, along with documentation of your past professional accomplishments, like awards, notable achievements, certifications, or other recognitions. Maybe you've delivered presentations at conferences or contributed to insights to professional audiences. Something like that can help. Let's see. Showing that you do have that past influence can support and demonstrate to USCIS that your future work will also likely be impactful. Other types of evidence. So if you have anything to show that you have that industry and media recognition, again, these can also carry considerable weight. For example, if you're an entrepreneur, you founded a company and you have attracted a lot of attention from industry associations, venture capitalist firms, or other media outlets. This is other evidence you could provide to show that you do have influence or credibility, even if it's at an early stage. And this type of evidence can help elevate your profile, demonstrate that you are well positioned to advance this proposed endeavor. Let's see. So this can be especially valuable for individuals who are working in maybe a non-traditional or emerging field where conventional forms of evidence may be less available. Um, let's see, specifically a little bit more for entrepreneurs. Other types of evidence you could include might be contracts or agreements with major organizations, or letters of intent indicating that you might have a future partnership or commitments with clients, evidence of your significant startup capital like grants or investor support connected to your business endeavor. These materials can help show that you not only have a viable plan, but you've also secured the resources, partnerships, or have that market traction um, to advance your proposed work. So together, all this type of evidence can really paint that compelling picture to USAS that you are well positioned um, to not only successfully carry out, but also continuing advancing that endeavor in the U.S. So regarding the evidence for this part of the submission, you can be somewhat creative. You be your best advocate. You know what evidence might be out there. Of course, if you have questions and you do have a lawyer, you should maybe bounce the questions off your attorney as to the type of evidence you think might be beneficial or supportive of your case. But you would be in the best position to know maybe what evidence does exist. So whether or not there's been articles written about you in the newspaper, whether or not you've participated in conferences or that sort of thing. Let's see. So, just regarding how to demonstrate that waiving that job offer and labor certification would benefit the U.S., here you would really just want to reiterate the evidence from prong one and prong two and emphasize that the value of your work is in the U.S. is so significant that waiving the requirements does serve that national interest. So, for example, if you're going to be working on problems tied to national competitiveness, national security, or critical U.S. priorities like energy, health, AI, infrastructure, that sort of thing. Here, you would really want to emphasize that granting that NIW better serves the national interest because the benefits of your proposed endeavor outweigh the protections offered by that job offer or labor certification requirement. Okay. So we'll talk a little bit about the recent trends and strategies with the NIW cases. So in the past couple of years, there has been a significant increase in the number of NIW applications filed. So for example, in 2018, there were about 8,000 petitions filed, but in fiscal year 2025, that increased to more than 60,000 filing. So, alongside that increase, we've also seen an increase in the requests for evidence and denials. So, our sense is that USCIS has been scrutinizing the NIW submissions more closely, particularly when it comes to that national importance requirement. So, just as another example of how the petitions are being treated, let's see, in 2025 quarter three, the approval rate was 53%. And then quarter four, it dropped to 36%. So you can see just based on the numbers a little bit how the cases are being treated. I think overall the environment for immigration, there is a higher scrutiny. So not only just for the NIW cases, but all around within immigration, there is a bit of a higher scrutiny on all types of cases. That being said, you can still definitely petition with a successful NIW case. Just, this is still a viable pathway for eligible applicants. It is important to note that the past approval trends don't guarantee future outcomes, but they do help illustrate what types of cases can succeed when they're properly prepared, properly supported with evidence. Okay, so here under the third point, so the government did issue some policy guidance that clarified the several national interest waiver aspects. So the last time it was January 2025, USCIS did issue a policy update. The guidance did explain how it will evaluate the national importance, including what types of evidence you would want to provide, and that can demonstrate that national impact. So occasionally we do see changes how USCIS will handle the cases and what they look at, that sort of thing. But since 2025, we haven't seen too much other changes besides that policy change that would be what the adjudicators would follow. Let's see. So another example maybe of how there have been adjudication shifts would be just, during the last administration, the federal government did focus more on the STEM field, so science, technology, the engineering, mathematics. Those did seem to be of particular national importance. The White House had publications go out on these, and people often use those to support their NIW submissions. Under the current administration, we don't really see those same types of federal publications regarding the STEM priorities. But even so, you can still definitely build a viable case if you are involved in the STEM fields. Okay, so just we would say, um, just a well-documented, well-tailored petition, you would really want to think about the evidence that you have, what you want to provide, what really holistically would make your case strong, and view of what the officer would be viewing. Specifically for the entrepreneur-specific strategies, we did touch upon this just a little bit on the other slide, but how to show that substantial merit or national importance can be supported by, again, if you have received significant media attention on the petitioner, on the business, or both. If you have awards, grants from government entities, letters from third-party industry actors, like your investors, if you have letters from the government agencies, if you can show evidence of revenue generation, the growth, the job creation, again, it does need to be significant. If you can show dissemination of results through conferences, patents, licensing, that sort of thing, that can really show that you do have that substantial merit or the national importance. Um, Ways to show that you are well positioned. This can be just, you have the ownership, you have this critical role within the U.S. entity. You can support it by providing evidence of your degree, certifications, letters describing your experience, evidence related to the investment interest, incubator, or accelerator participation. If you, again, have received government grants, you have intellectual property from the applicant or the company, even again, the media attention, revenue growth, letters from third-party reviewers, that sort of thing. Sometimes the evidence will overlap for different prongs, but you can provide that sort of thing. Okay, so just a little bit of what are some considerations when moving from a visa to the NIW. So let's see. So it's important to understand that when you are applying for a green card, there's actually two steps to it. The first step would be filing what is called the I-140 petition. This is the core of the NIW process. So the I-140 is that underlying underlying immigrant visa, where you must demonstrate to USCIS that you do qualify for this NIW category. So this is the stage where USCIS is going to evaluate whether your proposed endeavor has that substantial merit, national importance, and whether you're well positioned to advance it. When filing the I-140, you can file with what is called premium processing. This is offered for about $3,000. You can pay that extra fee to have the adjudication sped up in a way. So premium processing would guarantee an action on your case from USCIS, and by action, this can include approval of your case. It can include a request for evidence, even a notice of intent to deny. So it kind of pushes your petition up to the front of the line in a way. So USCIS would take action on your case within 45 days. But it does significantly accelerate the I-140 stage. If you choose not to file with that premium processing, the USCIS adjudication for just that I-140 petition can take 6 to 12 months. So it is important to note that the premium processing only speeds up the I-140 decision. It doesn't guarantee or accelerate the green card approval itself. So once you have that I-140 approved, you can then move on to the second step, which would be to obtain that green card. So there's two pathways to get that green card. You can do what is called adjustment of status by filing that I-485 within the U.S. So adjustment of status is if you are already here physically in the United States, you can apply for it that way. The other option would be to pursue consular processing. So consular processing would be used if you're outside the United States. You would apply for that immigrant visa at the U.S. consulate abroad by filing what's called a DS-260. Then after your interview with the consulate and approval, then you would be eligible to come here to U.S. to enter as a permanent resident. So whether you receive your green card quickly or must wait months or years does depend on what's called the Visa Bulletin. The Visa Bulletin is a monthly publication which shows the availability of the immigrant visa numbers for each category. So for the NIW applicants, you would be in what is called the EB2 employment-based preference category. And then to determine when you may apply or get your green card, you would check that visa bulletin each month. You would look up under the EB2 category, your country of birth, and see whether there's a wait time. So you would want to monitor your priority date, which is when you filed your I-140. And then once your priority date becomes current, you can file for that green card. And then it does need to be current before it can be approved. So another important consideration for that when you're determining whether or not to apply for that green card, the I-140 petition, is that you do want to really think about your non-immigrant visa status, that underlying status. And if possible, you would want to maintain it for as long as possible. Um, So for example, if you're here in the, I'll back up a little bit. Um, let's see. So if you are in the US and you have what's called a TN visa, something like that, your TN is expiring soon, you may want to renew that TN visa first before you file for the NIW. Um, it is important to think about the structuring the timing of how you file each of your petitions. And again, you would want to try to preserve that underlying non-immigrant status for as long as possible. Just because once you do file the immigrant petition, it can be more challenging to renew the non-immigrant petition because some non-immigrant petitions do require that that you have that intent to return home. So something, for example, again, if you have that TN visa, this is a visa that doesn't allow for immigrant intent. There are some categories of visas that do permit a dual intent, so meaning that you um, could maintain a visa like an H-1B or an L and have that intent to either return home or stay here in the U.S. Um, so it is, if you can maintain that underlying non-immigrant visa for as long as possible, if anything goes awry with the NIW petition, then you still do have that underlying status preserved, which would allow you to either stay here in the U.S. Or work or that sort of thing. So the I-140, it doesn't provide you with an immigration status. So even if you do file for that I-140 and it's approved, you should know that you're not given a formal non-immigrant or immigration status. It's just when you file that I-45, you will be just in a period of authorized stay. And then because of the current environment with this administration, we do say it's just better to be cautious and to make sure you are maintaining all your crossing your T's and dotting your I's, and just if you can maintain your non-immigrant status for as long as possible, that's best. Okay, so is the EB2 category current? For this month, so USCIS would be using what is called the final action dates chart. The EB2 is current on the final action dates for many of the groups, except for many of the countries except China and India. So this means you could file your Form I-485 if you are otherwise eligible, so your petition could be approved. You can also file for what is called the EAD and your advanced parole. Those would allow you to work here in the U.S. and then travel while your I-485 is pending. Unfortunately, some groups are backlogged, like China, India, so those green card approvals would not yet be available for the EB2. So some pros and cons for adjusting in the U.S. versus that consular processing. So the decision to adjust here in the U.S. versus whether or not you would want to pursue consular processing really would depend on your individual circumstances and your travel needs while your NIW is pending. So consular processing is often advantageous because it would reduce the risk of complications for individuals who do hold that temporary visa or otherwise need to travel abroad, maybe for family reasons or work reasons. When you choose that consular processing, you can generally continue to use your underlying non-immigrant visa, like if you have an E2 or a TN or some other temporary classification. Because you're not signaling to the government your intent to stay here permanently while you're pursuing adjustment of status. So instead, you're telling the government you're going to get your immigrant visa abroad at a consulate. For many people, this will just allow them more predictability and avoids travel limitations, which might be more attractive. Regarding the adjustment of status, this can be a good option in the right circumstances. It is usually more appropriate for people who are in the U.S. but don't need to travel internationally. So people who can remain here long term while that application is being processed. And again, while you file for that I-485, you can also simultaneously apply for that work permit and the travel permit. But just know that when you do file for something like the work permit or the travel permit, it can take 6 to 9 months before that is approved. So you can't leave the U.S. to travel without abandoning that I-485. So sometimes that restriction when you pursue the adjustment status in the U.S. Would be a drawback for people. So they may not want to pursue the adjustment status while they are here in the U.S. But again, this would probably just be an individual consideration on your own personal circumstances, whether or not you would want to pursue that adjustment here or go abroad. Okay, so quickly, just we have a case study here. We're a little bit short on time, so I'm not going to read through it, all of it, but it was just this case study related to an applicant who was an entrepreneur who formed a small consulting firm, which was focused heavily on improving services for U.S. veterans. This case was important for a a few different reasons because it really does show that there is a wide variety of endeavors that can qualify for this green card under the National Interest Waiver. So again, in this case, it was the field of veterans welfare. Um, but like for this applicant, if you can show that there is a particular limitation in the field and you can show that your proposed endeavor will have this broad impact of improving best practices for the field as a whole, as opposed to just providing good services to one particular employer or your immediate client, then you can maybe qualify for that NIW. You just want to be able to show that you are offering something more to the industry. So again, even if it's a small consulting firm, as long as you can show that broad impact, improving the practices in the field, it doesn't really matter what the field is. Let's see. Okay. Let's see if we go ahead and see if we have any questions. All right, I guess I don't see any questions. Give it 10 more seconds or so, but I know we're over on time. But I just want to say thank you for everyone for joining us. Thank you for Jay for joining and sharing all your expertise. And if anyone does have more questions for a specific case for your individual circumstances, feel free to reach out and schedule a consultation with any of our immigration attorneys. Hope everyone has a nice day. Thank you.